I am naturally just humbled to be amongst a lot of friends, colleagues, in and out of the government, former clients, and Andy. We had some fun in a few cases before the Supreme Court, and a lot of folks who have also served the public. It is one of the great privileges of being in public service to have the opportunity to, dip your toe into the river every now and then, and try to address some of the policy issues that over the years, from various experiences, you think should be going a particular direction. And again, I have the great honor to do that at the Justice Department. So I just want to thank you for the invitation to be amongst you guys, and on this really important topic. I don't think, people talk about trials and particular transactions going on, and there's lots of, media matters, but there's probably not a whole lot of issues, academic, that have real life implications as the intersection of intellectual property and antitrust law. So with that, I'm honored to be here for today's conference on the future of standard essential patents. And while the conference is forward-looking, it is fitting that we are here in Philadelphia, the original birthplace of the U.S. patent rights. The U.S. Constitution recognizes those rights in Article 1, where it empowers Congress to, quote, promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. All of you have heard that at least a couple of hundred times, probably just this past week. Why is that important? Many in the patent community champion Thomas Jefferson as the father of patent law. President Jefferson's contributions and public influence in this area cannot be understated, as he was the first lead patent examiner in the United States and made a number of influential writings on patent policy in the early years of the Republic. But lately it has become vogue amongst some critics of the U.S. patent system to selectively quote Jefferson to make the case that intellectual property rights ought to be reined in. I submit that the true father of U.S. patent law was the founding father, principally responsible for drafting the Constitution, James Madison. Madison wrote in the Federalist Papers that, quote, the copyright of authors has been solemnly adjudged in Great Britain to be a right of common law, and that the right to useful inventions seems with equal reason to belong to the inventors. Madison went on to note a policy rationale for patent rights, stating that, quote, the public good fully coincides with the claims of individuals. Analogizing patent rights to common law rights was a truly revolutionary position. In Great Britain, patents were conferred on an arbitrary basis by the king or queen to their political and economic allies, often with little regard for the utility of the invention. The notion that, quote, rights should belong to the inventors and that the rights coincides with the public good was not widely shared at the time. Indeed, Benjamin Franklin, the famous inventor, intellectual, and founder of this university, took a more magnanimous approach. He wrote in his autobiography that he did not oppose the use of his inventions without compensation, and he had, quote, no desire of profiting from patents himself and hated disputes. What'd you think of that, Judge? He hated disputes. The exchanges between Jefferson and Madison on the question of patent rights in 1788 are therefore illuminating of Madison's intellectual influence on this issue. Reflecting the general anti-monopoly sentiment at the time, Jefferson wrote from his post in Paris that, quote, the benefit even of limited monopolies is too doubtful to be opposed to that of their general suppression. In response, Madison acknowledged that monopolies, quote, are justly classed among the greatest nuisances in government. But he recognized a limited exception for patents. Quote, is it clear, he asked Jefferson, that as encouragement to literary works and ingenious discoveries, Monopolies are not too valuable to be wholly renounced. Madison answered his own question, demonstrating a nuanced understanding of how to balance concerns about monopolies with creating incentives to innovate. Monopolies are sacrifices of the many to the few, he said, where the power is in the many, not in the few. The danger cannot be very great that the few will be thus favored. It is much more to be dreaded that the few will be unnecessarily sacrificed to the many, close quote. Madison understood that replacing monarchy with democracy reversed the threat of the misapplication of power, creating a risk that patent holders might suffer from the tyranny of the majorities seeking to benefit unfairly from their innovation. Madison's views ultimately prevailed in the text of the Constitution, tying the right to a patent to innovation, or, quote, the progress of science and the useful arts. Remarkably, the word right appears only once in the U.S. Constitution, the original Constitution, which took effect 2 years before the Bill of Rights was ratified, and that was in the Copyright and the Patent Clause. The reward of a patent for a fixed period aligned the interests of inventors, who need incentives to innovate, with the interest of the public, who want the fruits of innovation. It was an ingenious compromise that unleashed the power of innovation in this young republic. This history would not be complete without noting that in the end, Thomas Jefferson shifted his perspective on patents to embrace a more Madisonian position. He wrote Madison in 1789 that he would support an article in the Bill of Rights specifying that, quote, monopolies may be allowed to persons for their own productions in literature and their own inventions in the arts for a fixed term. Jefferson went on to become the administrator of the patent system under the 1790 Patent Act, and he authored the subsequent 1793 Patent Act. And in his writings, Jefferson voiced his support for patent protection for invention on the ground that ingenuity should receive a liberal encouragement. In recent months, I found inspiration in this history and Madison's dogged perseverance in favor of strong patent protection, a view that stood at odds with much of the received wisdom and practice of the day. There has been a shift in recent years towards what I would call kind of a retro-Jeffersonian view of patents as conferring too much power that ought to be curbed, either through reinterpreting antitrust law or establishing patent policies of standard-setting organizations that favor implementers who practice on a patent when they build new technologies. Many advocates of reducing the power of intellectual property rights cite the so-called hold-up problem in the context of SSOs. As many of you know, I believe these concerns can be largely misplaced. Instead, I favor what I would call the new Madison approach to the application of antitrust law to intellectual property rights. This approach, if I may, has 4 basic premises that are aimed at ensuring that patent holders have adequate incentives to innovate and create exciting new technologies, and that licensees have appropriate incentives to implement such technologies. First, holdup is fundamentally not an antitrust problem, and therefore antitrust law should not be used as a tool to police FRAND commitments that patent holders make to standard-setting organizations. Contract, fraud law at different times are perfectly appropriate remedies. Second, standard-setting organizations should not become vehicles for the concerted actions by market participants to skew conditions for patented technologies incorporation into a standard in favor of the implementers, because this can reduce the incentive to innovate and encourage patent holdout. Third, because a key feature of patent rights is the right to exclude, standard-setting organizations and perhaps courts should have a very high burden before they adopt rules that severely restrict the right, or even worse, amount to a de facto compulsory licensing scheme. Fourth, consistent with the fundamental right to exclude, from the perspective of antitrust laws, a unilateral and unconditional refusal to license a patent should be considered per se legal. To understand what I mean when I say that patent holdup is not an antitrust problem, it's important to step back to consider the purpose of the antitrust laws, what it does and what it should not do. At its core, antitrust law aims to protect competition and consumers. Antitrust law is guided by a consumer welfare standard, which dates back to the origins of the Sherman Act. The ultimate focus on the consumer gained academic prominence in the late 70s and the 80s through the intellectual leadership of Judges Bork, Easterbrook, and many others. This standard sharpens the focus of antitrust scrutiny to anti-competitive practices that are harmful to consumers rather than competitors, so that the antitrust laws are not misapplied to advance social goals unrelated to the consumer welfare and efficiency of the markets. Importantly, however, the consumer welfare standard is not synonymous with a policy always favoring lower prices. For example, high demand for an exciting new product may drive up its price, but that may simply reflect consumer preference for a superior product relative to its alternatives. Antitrust law is intended to protect this behavior, not punish it, so that others will have the incentives to innovate and compete themselves, all for the benefit of consumers. Such dynamic competition should be encouraged by our enforcement policies. Rather than focusing on price in isolation, antitrust law instead protects consumers where practices also harm competition. That is, they harm some competitive process in a manner that causes harm to consumers in the form of above competitive prices, lower output, or reduced efficiencies. Indeed, directly showing harm to end consumers is not always necessary to prove a violation of the antitrust laws. For example, where collusion among buyers pushes input prices down, what economists would call a monopsony effect, that may violate the antitrust laws because there is harm to competition, even though it results in lower prices. This is where theories that unilateral patent holdup is an antitrust problem go wrong. Stating that a patent holder can derive higher licensing fees through holdup simply reflects basic commercial reality. Condemning this practice in isolation as an antitrust violation while ignoring equal incentives of implementers to hold out risks creating false positive airs of over-enforcement that would discourage valuable innovation. Advocates of using the antitrust laws to reduce the supposed risk of patent holdup fail to identify an actual harm to the competitive process that warrants intervention. If an inventor participates in a standard-setting process and wins support for including the patented technology in the standard, that decision does not magically transform a lawful patent into an unlawful monopoly. To be sure, that decision gives the patent holder some bargaining power in claiming a piece of the surplus created by the standardization. And it would require the patent holder to live up to commitments as they would have bargained for, enforceable by contract laws. But standard-setting decisions are intended to be a recognition that a technology is superior to its alternatives. A favorable SSO decision, like the patent itself, is a reward for an innovator's meritorious contribution whose wide-ranging benefits can ripple through the economy, contributing to dynamic competition. Arguments that inclusion in a standard confers market power that could harm competition typically rest on the unreasonable assumption that the winning technology is no better than its rivals. It is therefore unsurprising that proponents of using the antitrust laws to police FRAND commitments principally rely on models devoid of economic or empirical evidence that holdup is a real phenomenon, much less one that harms competition. Since holdup theories gained traction in the early 2000s, it's striking that they still remain an empirical enigma in the academic literature. Antitrust law demands evidence-based enforcement, without which there's a real threat of undermining the incentives to innovate. That's why I believe so strongly that the antitrust laws should play no role in policing unilateral FRAND commitments where contract or common law remedies would be perfectly adequate. I worry that Sometimes enforcers and courts have overly indulged in theories of patent holdup as a supposed competition problem, while losing sight of the basic policies of the antitrust laws. They lose sight of the fact that antitrust is not just remedial. It is, importantly, intended to deter through the threat of treble damages. As enforcers, we have a responsibility to ensure that the antitrust policy remains sound, so that U.S. consumers continue to enjoy the benefits of the dynamic competition and innovation, and so we do not export the unsound theories of antitrust liability abroad, where economically dubious enforcement actions can have serious consumer-harming effects on U.S. businesses, consumers, and workers. The second promise of the new Madison approach is that standard-setting organizations, as collective bodies themselves, should avoid overindulging theories of patent holdup to the detriment of the patent rights. SSOs should instead strive to ensure that their patent policies create maximum incentives for inventors to invent, or at a minimum, don't curtail the incentives to innovate, and for the licensees to have the proper incentives to implement those technologies. Achieving this goal is not an easy task. At minimum, it requires a recognition of the fact that implementer holdout poses a more serious threat to innovation than innovator holdup. To be sure, both practices threaten to undermine innovation through underinvestment in new technologies. But there is an asymmetry between the two. Innovators must make significant upfront investments in R&D in that technology before they know whether it will pay off, whereas the implementer can delay at least some of their investments in a technology until after the royalty rates have been determined and the technology and its success has been already assessed. To the extent antitrust law should play a role, it is to ensure that concerted action amongst implementers or innovators does not occur at any level of the supply chain. Specifically, as I noted this past fall, the Antitrust Division will be skeptical of rules that standard-setting organizations impose that appear designed specifically to shift the bargaining leverage from IP creators to the implementer, or vice versa. What do I mean by that? As enforcers, we have only limited insight into the patent policies of various standard-setting organizations, and we do not seek to impose a top-down mandate to skew the playing field clearly in the direction of the innovator or the implementer. But we expect there to be some symmetry between these competing interests, which manifests itself in two ways. First, at the SSOs, we hope to see a diversity of views represented on patent policy committees to give us confidence that patent policies are based on reasoned and unbiased decision-making. We strongly encourage SSOs to avoid allowing voting blocks of competitors to dominate decisions on patent policy or on which technology to incorporate into a standard. That kind of action would confirm the Supreme Court's observation that standard-setting organizations, quote, can be rife with opportunities for anti-competitive activity. Ensuring that no voting blocks take hold would help negate the risk that a rule or standard is the product of a buyer's or a seller's cartel. As long as an SSO's IP policies are the product of consensus or a clear majority that includes both standard essential patent holders and the implementers, the Justice Department should have no reason for concern. On the other hand, if an SSO's policy-making decisions appear to be dominated by either the implementer or the patent owner, and the resulting policies or standards appear to be skewed one way or the other, there could be trouble. Second, I believe innovation policy would benefit from a diversity of patent policies across standard-setting organizations. Optimally, competition can begin to emerge among SSOs within the same industry, with dueling patent policies that allow for the more efficient regime to prevail. Across industries, we expect that patent policies and the requirements for the inclusion of patented technology in a standard will vary depending on the technology in question. By contrast, I worry that advocacy by government agencies in recent years could lead standard-setting organizations to adopt a uniform approach to articulating specific commitments necessary for inclusion in a standard, an approach that may be skewed too far in the direction of implementers. The third premise of the new Madison approach to antitrust law and IP is to respect the core of what it means to hold an intellectual property right, namely the right to exclude. In his letters to Jefferson, Madison acknowledged that state-conferred monopolies are among the greatest nuisances in government, but maintained that these nuisances could be harnessed to serve the greater good of social progress and innovation through patent protection. His analogy of patents to the, quote, common law copyright of authors in the Federalist Papers is telling, because at the time, copyright of authors was understood as a property right. Equipping patent holders with the property right to exclude therefore goes hand in hand with the goals Madison envisioned for the U.S. patent regime. Understanding patent rights, once conferred as a form of property right, helps frame the current debate over injunctions and demonstrates how far we've strayed off course. Under the current Federal Circuit law, a standard essential patent holder faces significant difficulty in establishing a right to an injunction instead of damages. In a worrisome trend, some commentators have suggested that the mere act of seeking an injunction to prevent infringement raises competition concerns, and with a degree of hubris, litigants have advanced such theories as a basis for antitrust liability. Taken together, these trends fundamentally transform the nature of patent rights away from their constitutional underpinnings. What made America great? What made innovation in America possible for so many immigrants? They convert a property rule into a liability rule and amount to a troubling de facto compulsory licensing regime. It is not difficult to understand why that is the case, particularly in the context of standard setting. If a patent holder effectively loses its right to an injunction whenever a licensing dispute arises, or is deterred from seeking an injunction due to the prospect of treble damages, an implementer can freely infringe, knowing that the most he or she will eventually have to pay is a reasonable royalty rate. Implementers have a strong incentive to pursue this course while holding out from taking a license due to the high injunction bar for innovators that make frank commitments. It's a harmful arbitrage that should be discouraged. Some may be skeptical of this claim, given that, quote, willful infringement entitles a patent holder to compensation up to treble damages. But it is extremely difficult to prove willfulness, a demanding standard that the Supreme Court emphasizes should be limited to egregious cases of misconduct. Under recent developments of the law, the standard for obtaining an injunction and the standard for proving willfulness both work to the benefit of implementers and significantly limit the downside risk of infringement. This results in a de facto compulsory licensing for FRAND-encumbered patents that are deemed standard essential, and could serve as a disincentive for innovation or for patent holders to contribute technology to the standard-setting process in the first place. Deterring the right to enjoin other parties from infringement, particularly competitors, seriously reduces the incentive to innovate, much in the same way that the Justice Department's policies in the 1970s prevented field of use restrictions in patent licensing. This can cause great harm to consumers and is particularly problematic as more and more products and services come to depend on standardized technologies. The foregoing analysis leads me to the fourth and final premise of what I humbly call the new Madison approach, which is that a unilateral and unconditional refusal to license a valid patent should be per se legal. A refusal to license should not be a source for a competitor or a customer to seek treble damages under the Sherman Act. That is because competition and consumers both benefit when inventors have the full incentive to exploit their patent rights. This requires an assurance to inventors that they need not subsidize their competitors' business models if they prefer not to do so. The Supreme Court clarified as much in the Trinco case, explaining that a refusal to deal is not an antitrust violation if the parties have never done business with each other, because, quote, there is no duty to aid competitors. A de facto compulsory licensing scheme turns this policy underlying the Sherman Act on its head. To that end, I would urge scholars and policymakers to give careful consideration to the underlying policies of the Trinco decision. The Supreme Court emphasized that its earlier Aspen-Skian decision was merely, quote, a limited exception to the rule that there is no duty to deal under the antitrust laws. But some, particularly some of the newer enforcement agencies abroad, may think that, quote, this exception leaves room for a licensee to bring an enforcement suit if a patent holder terminates or refuses to renew the licensing agreement. More troublingly, some antitrust enforcement agencies think they have such a license to do so. The licensor thus could be forced to litigate for years the consequences of a business decision stemming from changing competitive dynamics or a new licensing strategy. Antitrust laws should not be used to transform an inventor's one-time decision to offer a license to a competitor into a forever commitment that the inventor will continue licensing that competitor in perpetuity. This past fall, I urge all of us who care about innovation to consider what I would say fresh thinking about the implications of standard-setting organizations and the proper role of antitrust law. So far, I've been encouraged and humbled by the positive response. To look forward to the future of standard essential patents, however, we should take a moment to look back to the wisdom of the Founding Fathers and the vision of James Madison in particular. He understood the value of strong IP protection as a means of fueling innovation and technological progress. I submit that this new Madison approach to these issues may help restore the promise of patent and antitrust law and unleash America's full potential for innovation. We should, in the words of Madison, continue to recognize that, quote, as encouragement to ingenious discoveries, patent rights are too valuable to renounce, and that we should fear not that the many are sacrificed to the few, but rather that the few will be unnecessarily sacrificed to the many. Thank you. Thank you very much.
Sure.
I'd be happy.
Makan has generously offered to take any questions from the audience. I will take the liberty of giving you the first one. I'm very struck by your speech, and I agree with it almost entirely. I know that many jurisdictions in the world don't. Mm-hmm. So Europe, China have a basic principle that there's such a thing as an excessive price for a patent license. In a world of international advocacy, what can we do in a constructive way to promote the kind of vision you're talking about in the dialogue you're discussing?
So I had the great privilege just over the last month, first being in China and then being in Brussels and having some discussions about exactly this topic. And both enforcers and the academia, particularly in China, had expressed a lot of interest and some level of probably concern about my USC speech. But I really do believe that everybody wants to do the right thing. I don't really impute any nefarious motives on a lot of our colleagues abroad. They were genuinely interested, and we spent probably more time than anybody should care to want to spend discussing exactly where I was coming from. And they understood. I think I want to say that, discuss not talking at people, but discussing where are we coming from on this issue. What is the monopsony effect in standard-setting organizations? What are the harms long-term? And not taking a snapshot of a particular technology or licensing regime where, oh, look at this, we could have a 5-10% cheaper product, where at the same time we're sacrificing the next generation of innovation. They got it. And I think a lot of my colleagues abroad, when we had heartfelt discussions about it, understood where we were coming from, and I don't think they took it as anything negative. I think the more folks talk about it and the more research is devoted to it, both economics and legal, scholarly research, the more everybody could converge towards the same idea. And look, it's not just abroad. We have differences of views even in the United States. We always do, right? We're lawyers. We disagree with ourselves a lot of times. But I think the more we have this dialogue internationally, the better it is, particularly in this area, because internationally, if you have an antitrust enforcement rule in a particular region, particularly with that they have economic consequence, like 1 billion population of consumers, that rule becomes the lowest common denominator. A technology company, whether it be Microsoft or Oracle or phone company, they are not going to develop a product with a different licensing regime in one country or another. It's a lot easier, and they'll figure out how to calibrate that. But you will end up, having, for lack of a better word, dumbing down your business strategy to that lowest common denominator antitrust policies, and that's where the real harm is. And it harms the process. I think in the United States, if a foreign country imposes rules that don't make economic sense. Professor Harris?
On your point about additional research, do you know if the division or is pursuing economic research now that would help us know better, say, where we're at 5, 10 years on the criteria dimensions that you've been talking about? Or is there a place that's happening in the university setting that you see this kind of research being done? Or is this something we really need to do more of?
I don't think we can do any less of. At the division, we're doing it. I've encouraged a lot of our 50 or 60 PhD economists who are working on it. We have a handful of folks who are continuing to look at that. Part of this is, modeling Luke Frobe, who is, a former colleague of yours, is my deputy for economics from Vanderbilt Business School, who is at the division. He used to be the FTC's chief economist, and he has written a lot on this. We have some resident scholars like Greg Worden and Jeff Wilder and a few others who are devoting some time to it. And we don't have an agenda. We want to just get it right. And there are a number of folks around, whether at Berkeley or George Mason or Pennsylvania, who are beginning to write more about it because there's greater prominence of the issue that didn't used to exist 15 years ago. So we are doing more of that within the division, but we're also encouraging others to focus on it. I think we all benefit. Yes. Well, on the second one first, as far as the FRAND issues, I think Judge Robart's excellent opinion is probably exactly the way you should address that. If somebody has not lived up to their FRAND commitments, they have violated some right? They've given somebody the benefit that they have not lived up to, and I guess not commenting on any of the facts because I'm just not familiar with it. But that's exactly the way you should do it. If you have not disclosed a patent and you have participated in it and you had committed to disclosing that patent, I'd say you probably, there might be circumstances you violated state fraud laws. The question is Where is antitrust the appropriate mechanism for a remedy of those types of ills? And that's the real important distinction. Not that I'm not condoning somebody who may have not lived up to their commitments, but how do you do that? Standard setting organizations used to be these wonderful organizations until probably 10, 15 years ago, where, you know, a whole bunch of engineers got in a room, said, this is the best way we can deliver, you know, electricity, because it is a much more efficient way, and it was one where I think it was encouraged. You don't want, you know, we don't want 20 different electricity outlets here. There was some efficiencies that were created. It later became a mechanism by which I think business folks and lawyers started populating some of the standard setting. Not always, but in some of them there is. And we have, you know, I've discussed this, where we're looking at some conduct in some standard setting organizations where you had collective action to prevent a particular technology from being implemented to the harm of consumers and the competitive process for no other reason but just pure economic, you know, anti-competitive behavior, at least in our view, that we're still investigating. That's where the harm comes. As far as, you know, should anybody, if you have 1,000 patents that are included in a particular technology, well, that is exactly the reason why you would want to have, you know, patent pooling or standard setting. The rules just have to be fair. And you should not read on those patents. If the folks have participated in there and made a certain commitment, you have the appropriate remedies. Should anybody come up and get an injunction? That's what the law Congress wrote. Congress can write in there, if they wanted to, say, look, if there's more than 5 patent claims to a particular product, you know, only 4 can seek an injunction once the 4th has done, or 2 or 3, however those rules are. You know, and there's a broad debate. You know, Congress has updated the patent laws several times just in the recent history. But for the antitrust laws to say you should not be able to enjoin, or for a collective group of customers of the technology saying you should not be able to, I think that's where the real problem is. And that's where, yeah, I think there's a proper policy debate under the Constitution that could happen in Congress. Look, as a matter of policy, I don't think it's a great idea that you have, you know, different standards, you know, either in the court or the administrative process, but that was Congress's policy determination. You know, you presumed that they considered it, and that was the ultimate solution they thought was better, was the best way. That's what should happen. I mean, I was involved in the Merck exchange matter. You know, the law, the statute did not allow for an automatic injunction. And I was a big advocate of the Supreme Court doing what it did do, because I thought the Federal Circuit had gone way too far on that, and those are, sometimes they need adjustments and recalibration of the patent system. But you can do harm if you're unnecessarily given injunctions, because you're now shifting the leverage to one side as opposed to the other.
Well, unfortunately, we're at that time. I want to personally thank you for giving what I think is an extremely inspiring speech. Please join me in thanking Makan Delrahim for his speech.
Thank you. Thank you very much. Thank you.